morning. It is Friday, March 27th, 9:39 a.m. The Senate Judiciary and Public Safety Committee will come to order. We do have a quorum present. By attending this hearing, you agree to adhere to the standard expectations and decorum of the committee, as explained in the written document available with the committee handouts, and any additional verbal instructions that I may add as chair. We're going to begin with Senator Wiklund, Senate File 4531.
Thank you very much, Madam Chair. Senate File 4531 is a bill that invests in some of our most effective mental health services in community life by specifically funding school-linked mental health, which integrates mental health where students need it most, by funding family peer specialists, which deepens the effectiveness of mental health treatment by helping families take meaningful steps forward with their children. It also would fund mobile crisis teams, which respond to and stabilize mental health crises in the community and connect to ongoing clinical care. And there's a grant that would go to healthcare professionals to help our helpers grapple with their experiences with traumatic events. Together, these grants build capacity in our communities to respond to traumatic events by targeting mental health care where it is needed most for students in our schools, families with acute mental health needs, those in immediate crisis, and our healthcare professionals who are on the front lines responding to traumatic community events. Funding will expand the number of schools with school-linked mental health services. It will launch family peer specialist professionals in new services. It would increase capacity of mobile crisis units to respond across the state, including Greater Minnesota. And it would support healthcare professionals with additional mental health care. And members, that is a summary of the bill. And if you have questions, I do have someone here who can answer more questions about any of the grants.
Thank you, Senator Wiklund. Members, do we have any questions? Senator Holmstrom.
Yeah. Thank you, Madam Chair. Senator Wiklund, is this available to, or will these funds be available to charter schools and non-public schools as well?
Senator Wiklund.
Madam Chair, Senator Holmstrom, yes, the school-linked behavioral health grants are available to all the public schools.
Senator Holmstrom.
So that does include charter and non-public schools that don't currently get the...
Senator Wiklund.
Sorry, Madam Chair, I don't know about non-public schools, and maybe, I don't know, Ginny Palin is here, and she knows more about how the grants are implemented in the school settings, so she could speak to that.
Thank you. If you can just begin by stating your name and title for the record.
Thank you, Madam Chair and members. My name is Ginny Palin. I'm the Executive Director for the Minnesota Association of Community Mental Health Programs. And to your question, Senator Holmstrom, the way the school-linked mental health grants is actually that the grants go to community-based providers who are then working across several different school systems and districts in their capacity to co-locate and embed these services for the students in those schools. So the grants themselves go to our community-based providers, and then they work with their with all of the schools across their service areas to ensure that the services get to where they need to go.
Senator Holmstrom.
Thank you. So I want to clarify, because I'm still not sure that it's being said. So I want to make sure that the services are available to children in charter and non-public schools as well, or at least clarify if they're not. So you said district. Will it only be traditional public schools that receive these services, or it will be available to all students across the state?
Ms. Phelan.
Madam Chair and Senator Holmstrom, I would have to have a discussion with the Department of Human Services who administers these grants, and we can follow up and get you clarity on that specific question.
Senator Holmstrom.
Thank you, Madam Chair. Senator Wiklund, would you be favorable to any sort of an amendment that might clarify that it would be available to all students regardless of school?
Senator Wiklund.
Madam Chair, Senator Holmstrom, I would like to clarify what actually is in the definition for the services before we do that, because if we add it here, this would be additional funding to go to an existing program. And so I would like to make sure that it isn't already part or how it's defined in there, rather than adding specifics to this language. If that would be okay, I can get back to the committee.
Senator Holmstrom.
Madam Chair, do you know the path for the bill?
The plan is to send it to finance.
Okay, thank you.
Senator Limmer.
Thank you, Madam Chair. Could I have council tell me what is the jurisdiction portions of this bill?
Thank you for the question, Senator Limmer. This bill was sent to us by Health and Human Services. Senator Wiklund, you're the chair. Are you aware why we are hearing the bill now in Senate Judiciary and Public Safety?
Madam Chair, Senator Limmer, it was my understanding that the Judiciary Committee was considering different methods of addressing traumatic community experiences, and we were asked to, we heard the bill in my committee, and then we are sending it here so that it could be heard and discussed.
Senator Limmer.
Madam Chair, usually we get bills that raise questions of liability or criminal and civil sanction. Sometimes there's other references that have a cross-reference with other areas of law, but usually there's something in every bill that has some reference to our jurisdiction. But am I correct in saying that no one in this room knows the jurisdiction of the Judiciary Committee on this bill? Why is it here?
Senator Limmer, I believe the plan was to assemble a package of bills to address gun violence, especially in our schools. There were a number of bills that we heard, last week throughout our committee this year. This is a part of that package that's to be assembled. I believe at one point there was thought of assembling it here in Senate Judiciary. It sounds like that may be happening in finance now, but wanted to make sure the committee was able to see the full bill in its entirety to have that discussion.
Okay, Madam Chair.
Senator Limmer.
Question for the author. Could you explain to me the connection between gun violence that the chair has made reference to and your bill?
Senator Wiklund.
Madam Chair, Senator Limmer, I guess I could go into each of the grants that are in this bill, how it might relate. I mean, obviously, school-linked mental health grants go to serve children who are in school settings who might have experienced gun violence. And the family peer specialists, it deepens the effectiveness of mental health treatment. And that treatment, might be a result of traumatic events, including gun violence. Mobile crisis teams, clearly they respond to crises in the community. Those can be mental health crises. And certainly we know that this type of event or situation that a person might be involved in can include guns, access to weapons, either to maybe take violence against themselves or against others in the community. So the mobile crisis teams are meant to help respond in a mental health fashion to these crises. And healthcare professionals, this is meant to help people grapple with their experiences of traumatic events. We've heard a lot about how first responders, healthcare workers, seeing the impacts of gun violence on children, on adults in their work. I think it is something that definitely they need access to mental health care as a result of these actions.
Thank you, Senator Wiklund. We also had a presentation from the Violence Prevention Project in this committee. We talked about the need for those early interventions as well. Senator Seeberger.
Thank you, Madam Chair. Thank you, Senator Wiklund, for bringing this bill. These are important services. In terms of school-linked behavioral health grants, this is something we spent a lot of time talking about during the seclusion work group that I chaired during the interim. They provide part of a comprehensive package for students who are in schools, and my son benefited greatly from these services. To clarify a portion of Senator Holmstrom's question, charter schools are public schools, and they are entitled to everything in terms of services that traditional public schools are entitled to, with the exception of some of the things enumerated under the Charter School Act. But I think sometimes there's a confusion that charter schools are not public schools. They are public schools. There's chatter over there that they disagree with what I said. They are public schools. They're public schools. Charter schools are public schools. And their services are available to students through school-linked behavioral health services in different settings and different scenarios. The point being, these are important services that benefit students. In terms of mobile crisis grants, mobile crisis units play a really important role in de-escalation of situations when someone is in crisis. If there's a behavioral crisis, instead of getting law enforcement involved and having negative outcomes for the person who's in crisis, mobile crisis units play a really critical role in de-escalating the situation and identifying the help that the person needs. I think it is entirely appropriate that this committee acknowledge the importance of these services and these grants, particularly when we spent a lot of time talking about what is it going to take to stop the gun violence that we're seeing in Minnesota. I've heard a lot of talk about mental health. It's mental health. You have to address the person that's behind the issue. Mobile crisis units do just that. And I can also say from personal experience, when my son was in crisis, there were times when he was arrested and put into the juvenile justice system, which I think is completely inappropriate when you're 11 years old, just for having a moment of dysregulation due to his autism. And there were times the mobile crisis units came out and routed him in the direction that benefited him. So thank you, Senator Wiklund, for bringing this bill. And I think members of the committee should recognize the value of these services rather than get bogged down in procedural matters, waste time, and quibble about what's a charter school and what's not a charter school. Thank you, Madam Chair.
Senator Koran.
Thank you, Madam Chair. It's unfortunate that we have to start off this long committee day with a partisan tone and partisan rhetoric. The issue that Senator Holmstrom asked about was a legitimate question about whether or not the charter schools and non-public schools are eligible for the services that the funds create in this program. It's a legitimate question. Of course, charter schools are public schools. Nobody's questioning that. It's basic. But the reality is charter schools are treated from a education finance standpoint a lot different than traditional public schools, and they're not eligible for a lot of the funding that traditional public schools get. And that's the reason for the distinction and the question specifically about charter schools. Now, to answer that question, it seems to me, when you look at the underlying statute here, which is 245-4901, it doesn't limit this to traditional public schools or public schools at all. So I think non-publics would be eligible. The question is, in practice, do these providers choose to work with non-public schools? And so maybe I can ask the testifier if you have any knowledge about that.
We'll go to the testifier briefly, Ms. Phelan.
Thank you, Madam Chair and Senator Kroon. It will vary across the state, and a lot of this is not necessarily because any particular community provider may not want to. I think it's really about capacity and how many providers and frankly clinicians that we have available to be able to enter into these agreements with different schools. I can certainly check and get information back to you on how many existing relationships and contracts there are across the state with non-public schools. So I think it is not for a lack of desire or want. I think we're just trying to balance capacity across our mental health workforce.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. Nobody on this side is not acknowledging the importance of this program. We're asking basic legislative questions here. And I think it's a legitimate question. While acknowledging the importance of this, whether or not the Judiciary and Public Safety Committee is the appropriate place to be, I guess, sending this money out from. I mean, this touches on Health and Human Services, it touches on education, and all of those things. And I'm not saying this is the wrong committee. I bet it's certainly a legitimate question without assuming that we're not acknowledging the importance of this program. This program is important. Mental health is important. I think this program does a lot of good. I'm certainly not against it. I just want to make sure that it applies to all of our students, traditional public schools, charter schools, non-public schools, that the providers are making an effort to work across the spectrum. And if resources is an issue, that's good because we're sending some more resources to them. So these are all legitimate questions. Whether or not it should be in this committee, I guess that's for someone else to decide. I don't have any specific objection against that. But, I don't think this committee has really intimate knowledge of this program because this wouldn't be something we would normally have in this committee, and that's the reasons for the question. So thank you.
Senator Limmer.
Thank you, Madam Chair. I find it unusual for me to explain my conversation earlier. Process is just as important as policy. And when you have a bill before us, I'm curious, there's 4 sections to it, all referring to funds to be used to the Commissioner of Health. 4 different areas. Oh, the Commissioner of Human Services are 3 of those, and 1 to the Commissioner of Health. So, as one may criticize our discussion about process, it's very important to talk about process from time to time, especially when it looks kind of unusual that there's not a single reference to a commissioner of a government agency that has jurisdiction in our committee. And so it is legitimate to ask that question. And as far as I'm concerned, every one of these areas is important for the health of the intended, in this case, I think it's children. And, we have all sorts of bills that go to health, talking about safety or the treatment of our citizens, but it doesn't come here. It doesn't come here at all. Madam Chair, what's the intention of the committee if passed? Where does it go?
Senate Finance.
Okay. So I suppose we could grant it our endorsement, but at the same time, I think we're wasting a lot of time talking about a bill that has no jurisdiction in our committee. And with 25 other bills for the 8 hours that we're in service today, to me, I just was wondering why we're wasting this much time or even reference to it. It's not part of a bigger bill for our committee. It's not an omnibus bill that we're considering. So I have to ask questions about process. Quite honestly, I think we should ask more questions about process in the last 4 years.
Senator Pappas.
Thank you, Madam Chair. I agree with Senator Limmer that we need to move this bill along, so I'd like to move that Senate File 4531 be recommended to pass and sent to the Committee on Finance.
All right. On that motion, all those in favor, say aye. Aye. Any opposed? Motion prevails. Senate File 4531 is sent to Finance. Thank you, Senator Wiklund.
Thank you.
Senator Clark, Senate File 4627. You're ready, Senator Clark.
Thank you, Chair. I bring you Senate File 4627, Independent Use of Force Investigations, Funding Increase and Appropriations. I'm here to present a bill that makes a targeted investment in our Bureau of Criminal Apprehension's Independent Use of Force Investigations Unit. This unit plays a critical role in Minnesota's public safety system. It's responsible for conducting independent investigations into officer-involved use of force cases that are often complex, high-profile, and deeply impactful for families and communities across our state. As these cases have grown in complexity, it's essential that the unit has the capacity to conduct timely, thorough, and most importantly, impartial investigations. This bill funds 2 additional special agents and 1 criminal intelligence analyst dedicated solely to this unit. These positions will help ensure our investigations are completed efficiently and that our prosecutors receive detailed and high-quality case information to make their decisions for their community. At its core, this is about maintaining public trust. Independent investigations must be fair, and they must be timely and transparent. This investment helps ensure Minnesota continues to meet that standard. Thank you, Chair.
Thank you, Senator Clark. Members, any questions? Senator Limmer.
Thank you, Madam Chair. Senator Clark, I'm curious about the word independent use of force investigation unit. Is that different than any other investigation unit regarding force?
Senator Clark.
Thank you, Chair. Good question. Thank you. No, I think the intention is that all are independent, and I believe, but I may go to Mr. Pappas to validate that is the title of the organization. So that is why it is capital letters and such. Mr. Pappas might have an answer, Chair.
Mr. Pappas.
Madam Chair, members, yes, the unit is called the Independent Use of Force Investigations Unit.
Okay. Thank you.
Thank you, Mr.
All right, seeing no other questions, Senate File 4627 is laid over. Thank you, Senator Clark.
Thank you.
We'll go to Senator Pappas, Senate File 4616.
Madam Chair, my witness isn't here yet. Could we just skip over me and come back?
We do have Senator Ling online. If you're ready to go, we can go to you, Senator Ling. Okay.
Just hitting all my buttons.
Great, and that is for Senate File 281.
Well, thank you, Madam Chair, and I do owe a little bit of gratitude for Senator Latz for being so gracious, not only last year when we heard the original bill, but as this bill has kind of taken the shape it has, and hearing the funding portion. And members, if you remember, this bill is the sextortion bill that's closely related to my community here in Olivia, Minnesota, but has been experienced throughout the nation and throughout the state of Minnesota as well. Really, just to give you a quick recap of the hearing that we had last year, and the situation is that Minnesota had no way to prosecute individuals that were fell underneath the extortion crime. However, they did so in an online manner and did so in a sexual nature. So that is what 281 originally started out as. It did have a funding mechanism included in that. But I'm here today to offer the A1 amendment, or have one of you on the committee offer the A1 amendment if we could, and then I'll talk about that for just a minute.
Yes, thank you, Senator Ling, and appreciate you grounding us in the reason why this is before us. Senator Clark moves the A1 amendment. All those in favor, say aye. Aye. Any opposed? Motion prevails, and the amendment is adopted. To the bill as amended, Senator Ling.
Thank you, Madam Chair. And so as this bill has been taking shape, there is a couple of legal hurdles that Council has advised us. And I think I need to, at this point, thank my co-author, Senator May Quaid, and the assistance that she has offered, and also the advocacy groups as we've gone through this, because it wasn't an easy push. So what the A1 does, it does really about three different things. It replaces that proximate cause language with substantial factor in sextortion resulting in great bodily harm. That's the first portion of it. And it also separates great bodily harm and death into two separate clauses and increases the penalty if death is the result of the sextortion case. So, and then along with, it does remove the awareness program that I think honestly is very essential to 281 being successful. But what we did is we separated that into two other bills. So we have Senate File 3938, which you as a committee had heard about 2 weeks ago or a week ago. So you're well aware of the funding campaign that goes along kind of hand in hand with 281. So it removes it from 281, and that is a delete all. So that, Madam Chair, is what gives this bill into shape. I think it is aligned with the other body. So, pending your approval, I think we're in a good shape. And I just appreciate the time this morning, and that's about as good as explanation as I can give.
Yeah, thank you, and thanks for all of your work on the bill, Senator Ling. Members, are there questions?
Madam Chair.
Senator Pappas.
Yeah, Madam Chair, just wondering, usually we get a fiscal note that talks about if there's going to be any additional prison beds as a result of this, and maybe we could ask our fiscal analysts about that.
Mr. Turner.
Madam Chair, Senator Pappas. Yeah, the fiscal note came back with no impact. It states that there aren't enough cases charged to significantly impact state correctional resources.
Senator Ling.
I'll put my hand up physically. So in Senator Pappas's, she's right in asking, and this is one of the challenges of prosecuting this case. My hope is, as time goes on and technology increases, that we have the capability to track these individuals down, and that is in lies the problem where we have had much trouble in the case locally. What happened here was someone overseas. It is not an easy to find the person accused of this crime, to find those people. It is tough, and I would hope that as time goes on, both the awareness campaign portion of that and the fact that technology on the whether it's a BCA or whoever the local law enforcement agency may be, has the ability to track this person down. Now we have the ability to prosecute these individuals for the crimes they're committing. So the fiscal note aspect to this, however zero, Senator Pappas, I would say possibly does have a fiscal impact in the future. And that's just me looking into my crystal ball and trying to say that is the way it's going to be. But worthwhile, I think.
All right, seeing no other questions, thank you, Senator Lang. Senator Pappas moves that Senate File 281 as amended be recommended to pass and referred to the Senate floor. All those in favor say aye. Aye. Any opposed?
Aye.
Motion prevails, and Senate File 281 will be sent to the Senate floor. Thank you, Senator Lang.
Thank you very much for this. I appreciate every vote today. Thank you.
All right, we'll move to Senator Pappas, Senate File 4616.
They have a tight schedule. Madam Chair.
When you're ready, Senator Pappas.
Thank you, Madam Chair. In 2023, the Clemency Review Commission was created to review clemency applications, provide recommendations to the Board of Pardons, and support victims, ensuring a more efficient process. The creation of the Clemency Review Commission addressed an unmet need related to collateral consequences for criminal convictions. Many individuals who served their sentences and turned their lives around were still being denied housing and employment decades later due to mistakes they made in the past. The CRC works diligently to ensure that all clemency applications are thoroughly and properly vetted so that decision makers are fully informed. The agency has doubled the amount of applications that are able to be heard, but the wait times to be heard and backlog of applications is quickly increasing. In its first full year, the CRC received 401 applications for clemency, a 152% increase from 2023. With current resources, the Commission was able to provide recommendations for 164 applications. Despite making huge strides in efficiency, the CRC is unable to meet the demand without additional resources and policy changes. I'm going to ask Carly Stark, the Executive Director of the Clemency Review Commission, to tell us about the changes in the bill that they're requesting. And Madam Chair, I do have an A3 amendment, and I actually want to slightly change that in that Section 7 of the A3, I think, is their current appropriation. And so I would like to keep the request for $375,000 in one-time money, and then just add the policy language. And I apologize to Mr. Pappas, who we went back and forth many times on this amendment. That was a little complicated. Not so much.
Thank you, Senator Pappas. Just some understanding. So we have the A3 amendment, which is delete everything. And then in Section 8,
I would change it to not be a delete everything. Okay. So we're keeping the original appropriation, the original bill, adding the amendment, but deleting Section 7 and Section 8. Madam Chair, I'm just assuming that we don't need Section 8.
Change this to 375. No, we'll just be adding that. My question is, do we need this language? No, yeah, be fine. Don't take this out and just join this. Okay. I just want to make sure I've got the language correct. So it's just discussing with council. I think what we'll do is we'll have the A3 amendment before us, and we will insert the language from 1.5 to 1.7 on the bill as introduced to the A3 amendment.
And then,
Senator Pappas.
Madam Chair and Mr. Pappas, do we still need the specific language in Section 8? Carly is saying we don't really need that, but do you think we need it?
Mr. Backus.
Madam Chair and members, not necessarily. I mean, they're kind of redundant, right? Because the original bill is appropriating extra money in fiscal year 27, and Section 7 is amending last year's appropriation to basically change the appropriation. But at the same time, my understanding is the bill is going to be laid over. So if it is moving, if it does get funded, I think Mr. Turner and I will combine this in a way that's consistent with your intent.
All right, great, thank you.
It is a bit redundant.
Okay. So I'll move that amendment.
Thank you, Senator Pappas. Were there any questions? Okay. All those in favor of Senator Pappas' motion, say aye.
Aye.
Any opposed? Motion prevails, and the A3 amendment as described is adopted. And we'll go to Carly Stark.
Thank you, Madam Chair, members of the Commission. I'm Carly Stark, the Executive Director of the Clemency Review Commission. The creation of the Clemency Review Commission has improved our clemency system. It has increased access so that more people are able to apply and be heard. We have a small staff of 6 full-time employees who are responsible for collecting court documents, providing notices, investigating applications, and coordinating meetings of both the Commission, which is 9 members, and the Board of Pardons, which is 3 members. The Commission has been able to maintain high standards for investigation and thorough review both before and during hearings, which I think is an incredibly important part of the clemency process. However, we are struggling as an agency to keep up with demand and will be unable to maintain these high standards that the public expects and deserves without additional resources and policy changes. So our one-time funding request would help us handle a growing backlog. I submitted a one-pager that talked about the numbers, and if our capacity does not change, that backlog will be over 1,500 applications by, I believe, 2032, and that represents a waiting time of 9 to 10 years. So that's with current capacity. However, there are also policy provisions that could help us manage this capacity issue without sacrificing public safety or the high standard that we apply to clemency applications. So in the policy proposal, you will see 5 provisions. One of them is to increase options for victims and survivors to submit feedback by allowing confidential written statements, regardless of whether there is a protective order. That will address situations where survivors in, for example, a murder case have security concerns, but there's never been a protective order on their behalf. And that is one of the #1 requests we get from victims, is to be able to provide confidential statements. The second thing it would do is fix the record sealing provisions to allow the Clemency Review Commission to share information when an applicant requests that we do so. Currently, once a pardon is granted, records are sealed, and then we are not allowed to acknowledge that a pardon has been received without a court order. That even includes if the applicant were to contact us and ask for a copy of their pardon certificate. We would not be able to help them. We also had a situation where someone was applying to be a private detective. The private detective board reached out to confirm that the pardon certificate was legitimate. I was not able to share that information, even though I know the applicant would have wanted me to. The next change is allowing 3-person panels to do a pre-screening or merit review of all applications. Currently, all applications must go through a full hearing, which requires notice to prosecutors, sentencing judges, and victims. That is regardless of the merits of the case. So I am proposing that we allow a 3-member panel to review cases and be able to recommend a denial without a hearing for cases that are unlikely to succeed. Especially in cases that involve victims, that saves re-traumatization of victims. And then the Board of Pardons is able to say, no, we think that deserves a chance, go through the hearing process, or adopt the denial. The second thing the panel can do is say this needs a full hearing, and then it goes through the entire process. The third thing the panels can do would be allow for an expedited process for specific limited cases. Those cases would be defined through rulemaking, and cases that would be subject to this provision would be nonviolent cases or potentially cases that don't involve a direct victim. So in those very limited cases, the 3-person panel could recommend a grant of a pardon without a full hearing at the commission level. And then again, the board would decide if they want to send it back for a hearing, adopt the recommendation, or hold a hearing at the board level. The fourth provision allows the governor to bypass the CRC hearing process and schedule the application for a hearing before the board without going through the clemency process. This would still require notice to prosecuting attorneys, sentencing judges, victims and survivors, and the public, but it would allow the board a little bit more flexibility in certain cases that are time sensitive or have a significant public interest. The last provision is, I didn't put this in the one pager because I don't know that it is under the jurisdiction of this committee. However, I will discuss it. It's for waivers of the initial waiting period and permission to reapply early. Currently, for an application to be eligible, it has to be 5 years from the date of discharge or expiration of the sentence. The CRC or the commission is allowed to review those applications outside of an open meeting, but the board is not allowed to do that same thing. So this would create an efficiency to allow the board to decide whether those waivers of the initial waiting period or permission to reapply early allow them to hear those more expeditiously. If they are approved, they then go through the full CRC process, which then triggers all of the notice provisions and retains transparency that we think is really important in this process. So that is a quick overview of those policy provisions. I think that this proposal is one that takes into consideration taxpayer funds and how to make this process more efficient so that we can give the public what they need and also efficiently use resources. So, thank you.
And
Senator Pappas.
Madam Chair, I did talk to the chair of state and local government, and they've agreed to waive any jurisdiction.
Senator Clark.
Thank you, Chair. Thank you, Senator Pappas, for bringing this forward. This is another one of these justice pieces for folks that we need to move through and give a path to full inclusion in society. I'd also just like to point out that this process that you're suggesting, the pre-screening of applications, is very similar to what we already do in the claims process. So in the claims process that comes in, there's usually about 100 that come before the claims administrators. And at the end, we, the legislature, act on 3 to 7 of them a year. And so I can't imagine if we as the legislature actually would need to look at each of those 100 without having pre-screening to make sure that the cases are well in order. So the pre-screening is a fundamental good government, good process improvement that we need to have and helps provide a clear path to justice for folks. Thank you.
Senator Holmstrom.
It must be nice to be a criminal in Minnesota. If you break the law, the odds of you actually getting charged in Hennepin or Ramsey County is abysmal. If you're an illegal immigrant and you choose to break the law, people will show up with whistles to defend you. And now this legislature wants to dedicate $375,000 and change all the rules to assure that if you actually get held liable for your crimes, we can try to get you out. Lines 1.26 and 1.27 of this are what allow the recommendation of a 3-member board to grant an application without a hearing, and if that vote is unanimous, I would make an oral amendment to remove those. We do not need to make this process easier. It is already a defined process that works well, and I would argue too well the way it's already written. I don't see why we would make it easier. Thank you.
Madam Chair.
Senator Pappas.
Madam Chair, I think it's important that we keep the temperature low because we do have a long day, as was stated previously. We are trying to make this process more efficient, but you have to, it's like people have served their time. They've served their time maybe 20, 30 years ago. And yet, we continue to punish them by bringing up this issue which interferes with their employment and their housing prospects. I mean, we want to integrate people who committed crimes back into civil society, because if we can't integrate them into civil society, perhaps they're more inclined to commit more crimes because they have no option for legal employment. So this is just a way to say you've turned your life around. Maybe you committed this crime when you were 18 or 19, and now you're 50, and it's still haunting you. You have, you've done a good job, you've been a good citizen, but yet we continue to punish people. So we're just trying to say that people do deserve a second chance. People do make mistakes, and they pay for their mistake. And now let's support them in integrating them back into as full citizens in society.
Senator Holmstrom.
I appreciate that sentiment. However, when you commit a crime that stays on your record this long, you separate yourself from society. And part of that record is letting people know, future employers, whatever it might be, that you are somebody who chose to separate yourself from the rest of society for personal benefit, whatever it might be. And this process exists. This amendment is a very simple request that we do not make the process easier. In fact, we hold it to the nature that it's been for a while, that has worked well, that serves people who may be worthy of the goal of clemency, I guess.
Madam Chair, I oppose
Senator
the
Pappas.
amendment, and I would disagree with you that it's worked well. The whole reason why we created the Clemency Board is it was too much of a burden for the Clemency Commission, because it was too much of a burden for the board. When you're talking about the Attorney General, the Chief Justice, and the Governor, they have other things to do. And they were not able to process very many claims over the years, very many requests. And it's a pardon. It's saying, we forgive you. I mean, it's kind of a, if you will, I'll use a religious, I'm religious. And I think that people deserve forgiveness when they are sorry and they pay for their crime, and that we should forgive them and give them a second chance to be part of society. And they've proven themselves that they are. Why should this follow you all through your life? When you were 18 or 19, you did something stupid. Senator Holmstrom, have you never done anything stupid in your life when you were like a young teenager? I mean, most of us did do things. And in fact, I think somebody just, as an adult, people are still getting DUIs. There was just one in the news today. People do make mistakes. And I think it's behooving upon us to say, yes, you made a mistake. Now you want us to forgive you. We forgive you. For heaven's sake, we forgive you.
I just want to make sure you're planning to move an amendment, Senator Holmstrom, and then Senator Kroon, did you want to speak to that?
I'll wait till after the amendment.
Okay. So, Senator Holmstrom, your amendment.
Yes, so thank you, Madam Chair. So yes, my amendment would be to, on line 1.26 and 1.27 of the A3 amendment, to strike those lines to, again, remove the ability for this three-member board to bypass the traditional method and grant an application without a hearing.
And just for clarification, your position on the amendment, Senator Pappas, is opposed. All right, on Senator Holmstrom's amendment, all those in favor say aye. Aye.
Aye.
Opposed?
No.
The motion does not prevail and the amendment is not adopted. Senator Kroon.
Thank you, Madam Chair. And there is a place for the Clemency Review Commission, and I understand, it does, you do have to have that preliminary process before it gets to the board, because you're right, they do have a lot of other things to do. So it's needed, but as I kind of look high level on this bill, I think that leniency right now in Minnesota is everywhere in our criminal justice system. It's in charging, it's in prosecution, it's in sentencing, it's in early release, it's in probation. and it's in the pardons and commutations process as well already. And while mercy and compassion have their place in a civil society, so does accountability and justice. And I think in the last 3 years, at least in Minnesota, the pendulum has swung too far in favor of leniency. And I think right now in Minnesota, the time is to swing that pendulum back more towards accountability and justice. So for those reasons, I have a difficult time supporting the changes in this bill. Thank you.
Madam Chair.
Senator Pappas.
Madam Chair, I just want to explain that this is not providing any more leniency. This is just making the process more efficient. So as Ms. Stark said, when you have a number of cases that you know the board is going to reject because they don't qualify, it's giving us an opportunity to reject the pardons before they get to the full commission or the full board. So when we talk about, the other thing we do talk about a lot is making government more efficient. And this is what this is trying to do, is make the process more efficient. Did you want to, Ms. Stark would like to comment?
Ms. Stark.
Yes, thank you, Madam Chair, Senators. I just wanted to just clarify that the line 1.26 and 1.27, that is just a recommendation to the board. So the board still has the ultimate authority of whether to grant or deny. And this was specifically drafted so that the criteria for that expedited processing has to be made through rulemaking so that the public is able to provide comments on what sort of crimes should be considered for that. And that does only involve pardons. The Commission has the authority to do rulemaking for nonviolent convictions already. We have not had the capacity to do that rulemaking, and I was told that the ability to have a 3-person panel hear those, which is what will actually make it more efficient, requires a statute change versus just rulemaking. So that is the intent of this, and it's supposed to be very limited. For example, we had a case that was a theft when someone was very young, and they stole diapers and baby clothes from a large box retailer. They admitted that they were so sorry, they never should have done that, but that is a crime of poverty, and I think that person deserves, the board agreed that that person deserved a second chance. And my question is whether we should be using the taxpayer resources to go through the full process for some of those outlier cases that are either very low merit or very high merit. It still has 2 levels of review, and we'll go through a rigorous investigation.
Senator Limmer.
Thank you, Madam Chair. We've had a lot of discussion about pardon boards over the years. Ms. Stark, could you tell me the old pardon board process, a person wasn't eligible to be considered for a pardon until, at least for a property crime, 5 years had elapsed. If it was a personal crime, 10 years had elapsed, and then a person having no criminal record during those periods of time was eligible for a pardon. Has that changed in the new process that we adopted a few years ago? Could you just explain that for me?
Ms. Stark.
Madam Chair, Senator Limmer, yes, that is a good question. So it did change. As you mentioned previously, if it was a nonviolent crime, it was 5 years. If it was a crime of violence, it was 10 years. And then if there were any if there was any crime of violence anywhere in your background, which includes drug possession, that would make it 10 years. So any intervening conviction would restart that 10-year clock. Now it is 5 years from the date of discharge or expiration for all pardons. For commutations, it is 5 years from the date of conviction or when half the sentence has been heard. Intervening convictions do not restart the clock. And that is actually what I'm trying to get at with the pre-review. If someone has a pending criminal charge, I would like those to be reviewed out earlier so that we don't have to go through the full process knowing that the board is unlikely to grant it.
And
Senator Limmer.
That old standard, the 5 and 10, that started at the end of the sentence being fully commuted. And am I of the understanding that that has gone away with the revisions that we had? Someone could actually be pardoned while still on paper, on probation?
Thank you, Mr. Chair. Senator Limmer. That is not the way it works anymore. So there used to be something called a pardon extraordinary, which is what we think of as a pardon. You know, it sets aside the conviction. And then there was a different form of relief called a pardon/commutation. And that is for people with active sentences. So the legislation changed it to be a pardon or a commutation. For a commutation, it has to be an active sentence, and the relief for that is reducing the sentence. Under the current statute, you cannot get a pardon if you have an active sentence. So in order for someone, even if it was a case of innocence, to get a pardon, they would have to first commute their sentence, and then they would have to go through the pardon process. So it has made it much more difficult to do a pardon if you have an active sentence.
Madam Chair.
Senator Limmer.
Mr. Chair.
Here we go again.
Yeah, here we go again.
Tricked you.
Senator Pappas, maybe I could direct you to page 3, lines 11 through 15. We've talked about, especially Senator Clark made a comment that stuck with me, that this process would involve full inclusion, would be satisfied by all players, whether they were victims or whether they were the perpetrator. But this makes reference to the governor may waive a hearing. Does that violate the full inclusion that we're trying to accomplish? And does it create a lack of transparency on the part of the public if the governor waives a hearing on this type of subject?
Ms. Stark.
Yeah, I'm going to let Ms. Stark, since this is obviously kind of complicated for us non-lawyers, non-corrections officials.
Mr. Chair, Senator Limmer, that is a great question, and I think the way this is written, we might need an amendment, because the intent of this is to allow the governor the ability to waive the CRC hearing and go to the board for a hearing. It's not to waive both of those. And if it does not read that way, we may need to amend it as it goes through the process, because the intent is to have it heard by the board.
All right. Thank you.
And trigger all the notice requirements as well.
Mr. Chair.
Senator Limmer.
Ms. Stark, could you give me an example of what would trigger a governor to waive the requirement?
Yes.
Ms. Stark.
Mr. Chair, Senator Limmer, I am going to refer to my notes. My staff and I were trying to brainstorm when this might come up, and we actually had a hard time trying to figure that out because it's supposed to be in very rare circumstances. We had a case recently where it was a commutation request, and it was based on a life-threatening health condition. Now, that is being managed by the Department of Corrections, but based on a lot of rules and regulations, being released to hospice care, you need a specific place to go. In a case like that, compassionate release through the Board of Pardons might be the right choice. But unfortunately, in that case, the person passed away before we were even able to hear the case because it takes so long. It's at the very minimum a 6-month process. So that is one of those cases. Another example would be we had an applicant who came before the board and had a very good case for a pardon. However, the board stated they weren't quite ready to grant it. They wanted to see more time between when the sentence expired and more sobriety before they were ready to do that. So that would be another case where they could say, you don't need to go through the Clemency Review Commission process, but you can appear before the board at a hearing so that, again, we don't need to use those resources because we've done the investigation. We will update the files and take it directly to the board.
Mr. Chair.
Senator Limmer.
If this passes into law, would you agree that the legislative intent on this particular portion of this bill, this process of a governor waiving a hearing requirement, is intended to be rare? I think you made a statement similar to that a minute ago.
Yes, I believe it should be in cases outlined in the statute where it needs immediate review because of time-sensitive nature. There's a significant public interest. We put the applicant has previously appeared before the board for cases like I just explained, and the applicant provides good cause to do so. So yes, it shouldn't be the majority of cases.
Okay. Thank you, Mr. Chair.
Any further discussion? I'm not seeing any. The Senate File 4616 as amendment is laid over for possible inclusion.
Thank you.
Next up, Senator Koran, Senate File 4543. Come on forward. All right, members, the expected action is to send this bill to the floor after we're done with it. Senator Koran, why don't you go ahead and tell us about your bill?
Thank you, Mr. Chair. Happy to present Senate File 4543, fairly straightforward bill. What it does is it adds the Office of the Legislative Auditor to the current law that permits certain agencies to request that the Bureau of Criminal Apprehension conduct a state and national criminal history background checks for applicants, employees, independent contractors, or vendors, and the independent contractor or vendor's employees. And so it's a fairly straightforward bill. And Mr. Chair, and I'd like to have our legislative auditor, Ms. Randall, provide you with additional details.
Ms. Randall, welcome back to the committee. Go right ahead.
Thank you, Mr. Chair, members. Nice to see you again. Thank you for hearing this bill. It is really a very straightforward bill. As you know, the legislative auditor audits the state's financial statements every year. As part of that audit, we need to access data at the Department of Revenue, which includes federal tax information, FTI. Beginning this year, the federal government is requiring anybody who accesses FTI to have undergone a fingerprint check. And so this bill simply allows the Office of the Legislative Auditor to request those fingerprint checks on our own staff. I will say we've worked very closely with the Department of Revenue, and they support the bill, and they're here to speak to it as well if you want. Thank you.
Thank you, Ms. Randall. Any questions from members of the committee or discussion? Not seeing any. Senator Limmer, would you like to move the bill?
Yes, sir.
Senator Limmer moves that Senate File 4543 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you.
Thank you, Mr. Chair and committee.
Senator Latz, welcome to the Judiciary Committee.
It is a pleasure to be here.
State your name for the record.
Madam Chair, Ron Latz, Senate District 46. Members, Senate File 4633 is part of a package intended to facilitate identifying and protecting against fraud in public programs. This bill would fund a public awareness campaign to increase the awareness of the BCA state program fraud tip line, which already does exist, and awareness of whistleblower procedures and rights regarding the reporting of fraud against programs funded or administered by the state. And then it gives authority for the commissioner to contract with a private entity for that public awareness campaign. It is anticipated to be a one-time appropriation. The copy that I have here has a blank in the appropriation amount. I don't know if we have identified a dollar amount yet. We expect to lay this bill over to pass it in anticipation of our third deadline. So we might have to wait to identify the dollar amount for that unless we've got one expected right now. I'll ask staff if there's a dollar amount that's been identified for this.
Mr. Turner?
Madam Chair, Senator Latz, no, we haven't had any discussions with Department of Public Safety.
Okay, Senator Latz.
Okay. Then I'll simply ask that we hear the bill and lay it over for possible inclusion, and we'll put a number in there once we get our budget figure.
Are there any questions from members of the committee? Senator Holmstrom.
Thank you, Madam Chair. Senator Latz, I think there's a lot of good here. Are you concerned at all about where the whistleblower protections might be falling short in Minnesota?
Senator Latz.
Madam Chair, Senator Holmstrom, I'm always concerned if we have identified gaps or problems in the statutes that protect whistleblowers. I'd love to hear any suggestions to close those up if they need to be. This is, of course, is for to fund a public awareness so that whistleblowers know they do have protections. I did carry and pass the False Claims Act in Minnesota a number of years ago. So there are already substantial incentives in place for people who know about fraud to identify it and to blow the whistle, if you will, or to bring a claim under the private attorney's general law to help recover fraudulently obtained funds. There are substantial protections in current statute also for current employees who are whistleblowers as well. But I'm certainly open to closing any or tightening that up if there are any suggestions for doing that. It wouldn't be a part of this bill, but yeah, I'd love to have a conversation about that if you've identified anything.
Senator Holmstrom.
Thank you, Madam Chair. I appreciate that. And I don't have the provisions in front of me right now, but my only concern would be if we're trying to get more whistleblowers with the retaliation, and we've heard hundreds of cases through the House Fraud and Oversight Committee. There are concerns about whether or not those protections are robust enough, and I worry about people experiencing retaliation from the administration. So that's it, but I appreciate your bill.
Thank you. Madam Chair, I know there are other anti-fraud provisions that are moving separately through the legislature, and my recollection is that they're strengthening the anti-retaliation provisions as a part of that. So hopefully this can be this whole effort can be a bipartisan effort to tighten down on fraud in Minnesota.
Mr. Chairman, I understand there's DPS staff in the audience if anyone has any questions for DPS. Okay. Anything else from members? Then Senate File 4633 is laid over for possible inclusion.
Thank you for the favorable hearing, Madam Chair. if you haven't figured it out, we're juggling multiple committee hearings and people need to be in 2 different places at one time, including me. So we'll be kind of jumping around the agenda for that as necessary. So I think we're going to wait here until we figure out what bill we have ready to go with the people that need to be here for it. Okay, so the next bill we're going to handle is Senate File 1163. This is Senator Marty, who is on his way to this room. Members, this bill was heard already last spring, and it was laid on the table. So we are going to take it from the table and entertain a motion to re-refer it to state and local government, which would be its next stop. Senator Marty, Senate File 1163 is taken from the table and is now before us. Would you please just give us a 30-second description of the bill, then we're going to update some of the dates in there and we'll move it on since we've already heard the bill on the merits.
Yes, thank you, Mr. Chairman, members of the committee. Yes, you have heard this bill before. This bill would create an Office of Animal Protection in the Department of Public Safety. I think this is a thing we recognize the importance of addressing this. There are so many connections to animal abuse and animal cruelty, to human violence and so on, and I think we want to make sure we address this. I think having a state office is very important. You and I both understand the financial difficulties of this, but I really appreciate your consideration to move it on to the next committee for further consideration.
Mr. Pappas as to dates that need some updating.
Mr. Chair and members, on line 5.19, delete 2025 and insert 2026. On line 5.22, delete everything before the second $sign and then delete R and insert is.
Senator Pappas so moves. All those in favor say aye. 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 Opposed. Motion prevails. The amendment is adopted.
Thank you, Mr. Chairman.
All right, the fiscal amount is blank right now, so I guess we'll leave that to the, if it gets to the Finance Committee, you can figure out what dollars you need in there and how you're going to pay for it. All right.
Understood.
So then we have Senator Wiklund moves that Senate File 1163 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. I'm sorry, is there a discussion? Senator Limmer.
Thank you, Mr. Chair. Senator Marty, I just wanted to know, how is animal cruelty handled now and what department does it? And why do we need an official establishment of an Office of Animal Protection?
Sure.
Senator Marty.
Mr. Chairman, Senator Limmer, basically right now that's one of the things we don't have a process for dealing with it. It's handled locally by local prosecutors, local law enforcement, and they're begging for help and so on. And the hope is that we can create this office that will be able to help pull resources together for helping county attorneys and others, city attorneys, know how to handle the prosecution and so on.
And Mr. Chair, do we know what the dollar amount
Senator
may
Limmer.
be?
Senator Marty.
Mr. Chairman, Senator Limmer, we've been talking for the last couple of years. I mean, we'd like to have a bigger thing, but we were proposing $350,000 to establish it. It means there'd be a director and another couple of staff people, and they'd be working with task force. It would be their job to try and help facilitate where the gaps are. We had testimony from some prosecutors and some animal control officers and others on the help that's needed.
Okay, and Mr. Chair.
Senator Limmer.
In the interest of balance in writing a law, I'm curious about the line on 1.20 and 2.1. It seems like that line that says animal cruelty is an ongoing occurrence throughout Minnesota linked to human violence and criminal activity. It almost sounds like a finding, Mr. Chair, and I'm just wondering if that could, in the process of prosecution, that might be enhancing inadvertently a prosecutorial role. And I'm just concerned if that's necessary in the bill.
Senator Marty, what do you think? Is it necessary in the bill?
It's not necessary in a sense, and again, this does not go to the prosecutors. This is just for what the office is supposed to be working on. And I think that's a reality, a sad reality, that domestic violence is often tied to this.
Mr. Chair, I would agree that it is a reality. I don't know the statistics of an ongoing occurrence, and in 10 years from now, if this is in the law, I'm not sure if the ongoing occurrence would continue. Let's hope it does not. So I'm just wondering, you know, we write things into law and it kind of has a permanent fixture in the law, and I'm just wondering if we should keep it in.
Mr. Chair,
Senator Marty.
It's up to the committee and or state and local committee, but I mean, I think it's a reality and I think it's fair to have in there, but I understand if people would rather not have it in there.
Yeah.
Senator Limmer.
Well, Mr. Chair, in the interest of writing a balanced bill, I would move to strike the lines found in 1.20 and 2.1 after the second period, strike the remainder on line 1.20 and on lines, and continue the strike on lines 1.21 through the first paragraph, or not paragraph, period.
Senator Limmer moves to strike everything on line 1.20 after the period following the word office, and on line 1.21 up to and including the period. Any discussion? Senator Westland.
Just briefly, I mean, I'll probably vote for the amendment, but I do want to say that when we're talking about ongoing occurrences, this is a significant problem, and I think that it is something that has been on the increase. There are reports that Humane Society itself investigates over 1,600 reports of animal cruelty annually, so it is actually a fairly significant problem, and if we do not currently have a process to help address those cases, I think establishing this is important, but I am probably not going to die on the hill of whether or not we should have this sentence in the bill.
Mr. Chair.
Senator Koran.
Thank you, Mr. Chair, and I'll just echo that. I love animals. I just want people to understand what we're doing here with this amendment. It's deleting a purpose statement, which is a reason for supporting the bill, but it doesn't need to actually be in the bill. So this is just a nuts and bolts legislating thing, and it doesn't mean that by voting for the amendment, we disagree with the sentence that we're striking.
For your information, for what it's worth, the chair will be voting yes on the amendment. Any further discussion on the amendment? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion on Senate File 1163? Not seeing any. Senator Clark moves that Senate File 1163 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed? Motion prevails. Sorry, Senator Westrom. I'll try to pause a moment while we wait for you to vote.
Mr. Chairman, thank you,
Senator
members
Marty.
of the committee, for moving on. Thank you.
Thank you. Members, next up, Senate File 4511, Senator Marty.
Thank you, Mr. Chair, members of the committee. I have an A5 delete everything amendment that I think is maybe not in the packets.
Members, this is in your packets. This is an author's amendment, as this is the first committee for this bill. Senator Clark moves adoption of the A5 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Marty.
Thank you, Mr. Chair, members of the committee. I think many of you are familiar with what prediction markets are. A year ago, I think almost nobody knew what was happening with them, and now it's grown from very little to massive amounts. And the fear is, at the rate it's growing, that it's going to blow away every form of gambling regulation we've had in Minnesota. And Senate File 4511 would make it explicit that using predictive markets, which have been used for commodity futures, other things like that, would make it explicit that using these predictive markets for betting on sports, betting on politics, betting on terrorism, betting on things like that is betting, and it's unregulated betting in Minnesota law. As I said, I think it's urgent because we're finding out that it's growing so fast, and every form of regulated gambling in Minnesota is saying, wait a minute, we have to follow these regulations. They're just coming in and doing this. And that's why this bill has not just bipartisan support, which is never surprising on gambling things, but importantly in gambling issues, support from both supporters and opponents of sports betting. I'm not a proponent of sports betting. Senator Klein, another co-author, is a strong proponent of it. And I think that's because we recognize what's happening here. And I want to say real quickly that commodity futures and speculation on future price of things like that is long been practiced. It's regulated by the Commodity Futures Trading Commission, and we are not touching that. We are touching the futures, the prediction markets, when they are betting on certain things that are clearly betting. They're not investment products, but betting on athletic events, on casino-type traditional games, war, national emergencies, politics and government, the courts, legal action, whether a person is going to be convicted, who's going to win a jury trial, size of settlement, even assassinations. And there were some individual apparently you bet anonymously in this case, won $500,000 betting on when the Iranian leader was going to be killed. And again, this happens in many cases where insider information can be extremely warping the stuff, and that the predictions themselves may be influencing political decisions and military stuff and elections. This bill would take any of those prediction markets that are any person who's creating a prediction market or operating, manage them, or participating in doing business with them in order to facilitate them, that would make that a felony. We have a process in here that if you are doing this, the Alcohol Gambling Enforcement Division at DPS would send out, they're constantly investigating things like this. This would give them more tools to send out cease and desist letters, and if they do not comply, then they would have, it'd be guilty of a felony at that point. We make it clear that this does not affect any activities that are not bets under current law, including social bets. You can bet on sports, you just can't have a bookmaker making the odds for you. It exempts everything like insurance, everything else. And I want to say one more thing before going through for discussion, and that is that like insider trading in stock market, like insider knowledge in politics, where members of Congress doing insider trading kind of stuff has been long subject of corruption things. As I said, somebody bet $550,000, won $550,000 on a very long shot odds, suspiciously timed on certain events in Iran. In fact, the Israeli government has now arrested more than this, but charged 2 people on suspicion of using classified information to place bets about military operations on Polymarket. They say they're using classified information, and they're betting on specific strikes in a war, which can influence the war, everything else. It's open to corruption. We could bet on the odds of this bill becoming law. And you could help somebody with insider information, and we could warp the outcome in order to facilitate that. A number of states are requiring public officials and others not to bet or use insider information on this, but we think it's best to just do what's clear. This is illegal betting under Minnesota law. We want to clarify that using the prediction market as a loophole is not there. So with that, Mr. Chairman, I'm happy to stand for questions, and I have the Director of the Alcohol Gambling Enforcement Division, John Anglin, here, and Phil Brodeen, I believe, is also here, who's an attorney who's worked on gambling law and was helpful in putting the bill together as well.
Thank you, members. The entire bill is within our jurisdiction, but you should, I'd encourage you to pay particular attention to the enforcement provisions, which is more specifically within our coverage. This bill will go to state and local government from here. I'm not sure of its path after that, but
Mr. Chairman, this is likely to end up as sorry, I didn't mean to interrupt. It's likely to end up as a late bill, and we understand that. I think there's been a sense of urgency among leaders in all the caucuses and people in the state that, again, if we don't regulate it this year, cat's way out of the bag and it's going to be hard to pull in. So, yes, it's a complicated path, so I appreciate that.
Any discussion on Senate File 4511? Senator Holmstrom, then Senator Koran.
Thank you, Chair Latz. Senator Marty, thank you for bringing this bill. I actually really agree with the concept. I think that this is a serious problem that we're facing, and I speak somewhat often about how much I don't like when we put forward legislation that exempts ourselves from the consequences of our actions. And if I was to offer anything, an advice or a potential amendment to work with you on, I'd like to see even higher penalties for politicians in this bill, because a lot of things on production markets we see that we actually have influence on. I think it's particularly egregious that we're allowed to begin with. So I think I'd be interested in increasing penalties for those of us who have a say in these matters.
Thank you, Mr.
Senator Marty.
Yeah, we got to make sure people aren't doing it. The trouble is, how do you regulate? How do you stop it? How do you expose it? So what we're trying to do here is shut down the entire project before it comes in more. It's here. Calxi is advertising itself as the only nationwide legal sports betting operation, and it's not legal. And we want to make it clear it's not legal and stop it. So we're going after the penalties here are not because you placed a bet or anything. That's something we have to have for insider stuff, especially here. But this bill is not going after the people who may have placed bets. This is going after taking out this practice, which is clearly violating what our alcohol gambling enforcement folks have been trying to shut down illegal gambling in Minnesota. And again, thank you. I share your feeling that that's a big problem.
Senator Koran.
Thank you, Mr. Chair. And yeah, the scope of the betting on this is just, it's mind-boggling how expansive it could be, and how I think the potential problems, we can't even think about all of them at this point. So I think it's abundantly obvious that this needs to be regulated more than it is, of course. And I'm not a constitutional expert, but I'll wade into this a little bit because this is like the wild, wild west right now on which agency is going to be, or agencies plural, are going to be responsible for regulating this. I don't think anybody knows how that's going to play out. Certainly this is going to be litigated. It already is being litigated if we pass this bill, we'll be entering into that litigation. It's unavoidable. And normally I'm somebody who's talking about, have you thought about federal preemption? Wouldn't this be federally preempted? I think in this case, it's far too uncertain to kind of know how that's going to play. I think the litigation is kind of in its infancy on that. And also, we're not even quite sure which federal regulators are claiming jurisdiction. Obviously, you mentioned the Commodities Futures Trading Commission. I think they're claiming exclusive jurisdiction, but I can see the SEC getting involved and other agencies saying, well, wait a second, this impacts us. And I'm not even sure the federal government knows exactly how they're handling this right now. It truly is the wild, wild west. So normally I'm cautioning us on federal preemption when the federal government asserts itself. I think ultimately Congress does need to do something about this. This needs federal statutes that apply to this. That would be the best case scenario, but that doesn't mean we need to not act at all while all of this is being hashed out. So that's a really long way of saying I think this is necessary despite the legal uncertainties. Thank you.
Senator Marty.
Yeah, Mr. Chairman, I think you're right about that. I mean, they are claiming, Calci and Polymarket are claiming that the CFTC is the only regulator in states that have the ability to, but clearly what we're saying is when you're betting on sports, that's not commodity futures, that's betting on sports. And we want to, in our alcohol gambling enforcement folks, they're used to offshore folks and doing it. And this approach, I think, actually says, hey, they can, if I'm dealing with them, if I'm helping facilitate their business here in Minnesota, they can send cease and desist letters and they can shut them down, which may, we hope, clamp down on the stuff, even if the federal government isn't going to act and so on. But I share your points.
Mr. Backus.
Mr. Chair and members, and I apologize to Senator Marty, there's, I think, a technical amendment that could be made on page 4, lines 4.18 to 4.20, that definition of public property, that was part of an advertising prohibition that was in the earlier version, is no longer there. So you would want to delete lines 4.18 to 4.20.
Senator Marty.
Mr. Chair, that's correct.
Any discussion on that proposed amendment? Senator Kroon moves adoption of the amendment as described by council. All those in favor say aye. 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 Opposed? Motion prevails. The amendment's adopted. Any further discussion on Senate File 4511 as amended? Not seeing any.
Chair.
Oh, you have your hand up. Senator Westrom.
Mr. Chair, just a clarification, Senator Marty. In the ag world, there's a lot of contracts given for future, predictions or security for a grain market that goes up or down. And I'm just wanting to address that issue. Reading through the bill quick, you've got contracts, commodities. Can you just reassure us that this has no effect on the grain markets or farmers or those that hedge, buy or sell contracts as part of their marketing strategy for farms, and always a protection against pricing going up or down? Diesel fuel is a big thing in the recent Iran war with the prices going up. It's something that some farmers would have entered into potentially if they had a sense that any of this was happening. So I just kind of want to address this issue and make sure we're not sweeping up a big sector of the economy that we haven't talked about.
Senator Marty.
Mr. Chair, Senator Westrom, thank you. Yes, we are very aware, again, commodity future trading is an important part of farm economy and trying to figure out for farmers to try and figure out how they get fair shake for their products. And in the bottom of page 2, you can see the language in the A5 amendment. what are not bets. The following are not bets, and this is existing law. Number 2, a contract for purchase or sale at a future date of securities or other commodities. And all we're doing is adding except is provided in this section 609-7615, which you see on page 3. And that's where it says, hey, if these futures trading stuff is betting on sports, on politics, on disasters, on things like that, those are what we're banning. We're not touching the rest of it. We're acknowledging there's a very legitimate market there, just like we're acknowledging that insurance markets and so on could be seen similarly, but that's already regulated. We're exempting the things that are regulated by CFTC and also by our state laws on all these other things, either existing gambling or other things that you raised the right question, but we are clearly exempting it.
And Mr. Chair, Senator Marty, thank you. So if I understand it correctly, its primary prohibition is in tying something to a certain result in the future is the main thrust of your legislation. If I get
Senator Marty,
is that a big part of it?
Mr. Chair, that's the starting point. If it's not betting on future outcomes of things, it wouldn't be touched by this anyway, but we're not talking on speculation or future outcomes in areas that are legitimate, like the commodity futures. We're simply saying if you're betting on future things related to sports outcomes and these 5 or 6, 7, 8 areas we list, those are the areas where people are doing it purely as gambling. It has nothing to do with any investment product or anything else. So we are not, I shouldn't say we're exempting those things. We're not touching, only things we're prohibiting is the use of that type of product in these areas, the sports or terrorism or politics or courts, etc.
Very good. Thank you. I just wanted to make sure we
Senator Wellstrom
didn't have that cat caught in the net, but appreciate your explanation.
Any further discussion on Senate File 4511? I am not seeing any. Senator Clark moves that Senate File 4511 as amended be recommended to pass and be referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed?
Aye.
Motion prevails.
Mr. Chair and members of the committee,
Marty.
thank you very much, and I know you've got a very long agenda, so thanks for taking these up.
You're welcome to stop back and watch if you wish to do so. He's getting out of here as fast as he can. Look at him go. All right, next up, Senate File 3173, Senator Boldon.
Mr. Chair, when you announce a bill, could you just say the number on the agenda too, because it'd be quicker to find it when we're bouncing around a little. Just a little tidbit of help if that would be workable.
Well, the main agenda does not have numbers. You may have assigned some yourself, which is great. This is Senate File 3173. Senator Boldon addressing private equity ownership of single-family homes. Members, this is not the first committee. It comes, well, kind of is. I'm not entirely clear. It started out here, went to housing acted, sent it back here. So this is not the first committee. There is an amendment in your packet, which we will not be able to treat as an author's amendment. But the topic is entirely within our jurisdiction, so Senator Boldon, why don't you tell us about the bill, and then we'll consider the amendment.
Thank you, Mr. Chair. Very good. Thank you, members, for hearing this bill. Good morning. The bill before you today may sound familiar. As you said, it has been around for some time. I have been working on this concept as long as I have been in the Senate. This bill prohibits private equity companies from having a direct or indirect ownership. If we adopt the amendment, it narrows it to allow them to have 100 single-family homes acquired on or after August 1st of 2026. There are some additional exceptions, including investors' personal homes, land trusts, family entities, new builds, or group homes, for example. The Attorney General's office has enforcement authority over this limitation, which could include injunctive relief and civil penalties up to $25,000. And this bill applies additional penalties of up to $100,000 per violation, with proceeds being redirected to the Affordable and Workforce Homeownership Program. The AG's office is required to provide a 90-day written notice to a private equity company before enforcing any violations. Homeownership is something that continues to be out of reach for many Minnesotans, largely people of color and working class families. In Minnesota, the reasons are varied, from lack of supply to high cost of housing to discriminatory practices in the market, and of course, corporate ownership of single-family homes. This bill proposes one solution to the problem of corporate homeownership by creating a more level home buying market that gives more space for everyday Minnesotans who desire to own a home and a chance in the marketplace. The Minneapolis Federal Reserve released a study in October of last year on investor home purchasing, which included significant findings, including that there are 60 census tracts across the Twin Cities where at least 10% of single-family homes are investor-owned rentals, and at least 10 tracts where more than 20% are investor-owned. In one neighborhood close to the U of M, almost 43% of single-family homes are owned by investors. This is a growing problem. It has increased from 4% in 2022 to close to 5% in 2024, and that growth represents about 5,000 homes. A Realtors report in 2025 also indicates that 13% of homes purchased nationally in 2024 were bought by investors. And a Minnesota Reformer article from November of last year suggests that nearly 9% of residential parcels across 500 U.S. counties are owned by a corporation. We have also seen when large corporations own, especially in low-income areas, they often have little to no incentive to properly maintain those properties. They jack up the rent and are often absentee landlords, leaving tenants paying very large amounts to live in poor conditions. So for all of these reasons, as we continue to work to increase the supply and affordability of homes, making sure that investors and wealthy interests aren't pushing families out of their communities needs to be a top priority. Every Minnesotan deserves the option of homeownership. And this bill provides an opportunity to stop private equity companies with deep pockets from pricing regular Minnesotans out of their homes. And lastly, Mr. Chair, I would just draw members' attention to the letters of support in your packets from the Council of Minnesotans on African Heritage, Habitat for Humanity, and Homeline, as well as several letters from individuals sharing their personal experiences with challenges related to private equity in housing. When it is appropriate, Mr. Chair, I'm happy to describe the amendment and how we got to that.
Yeah, I don't see any testifiers signed up, so why don't we go ahead and do that?
Thank you,
Members, the amendment is in your packet. Go ahead, Senator.
Thank you, Mr. Chair. So, as I said, this is a bill that we have worked on over years. This amendment represents some compromise language in working with my Republican counterparts in the Housing Committee and in connection with the Attorney General's office, seeing what is workable for them. So this, like I said, is compromise language. It narrows the scope of the bill and allows private equity companies to own up to 100 single-family homes. And just would stop them from buying their 101st. And provide some additional information that the Attorney General's office needs in order to do the enforcement we're asking them to.
So, Senator Boldon, I'm not entirely familiar with this investment space. Can you maybe give me a little more information on what private equity company means?
I can. Mr. Chair, thank you for the question. I would draw members' attention to lines 1.17 of the first engrossment of the bill, which describes a private equity company as a group of investors who primarily engage in the raising or returning of capital and who invest, develop, or dispose of specified assets. And then it goes on, and there's a number of exceptions there. It doesn't include a government entity, doesn't include land trusts, certain nonprofits, a corporation that is geared towards building. We don't want to stop new construction. It does not include family entities. It does not include real estate investment trusts. And then with the amendment, it narrows it even more so that it allows these private investment companies to own up to 100 homes.
So, Senator Boldon, if an individual has a business partner, for example, and they borrow money from a bank to invest in single-family homes intending to rent them out, would that be considered a private equity company, or would that be considered not covered by this bill? I'm just trying to figure out the scope. Senator Boldon.
Thank you, Mr. Chair, for the question. So if those two friends or business partners are doing that for the purpose of investment, they can do that. They can own up to 100 homes if we adopt the amendment in this case, but not over 100.
So that business arrangement would be considered a private equity company? Is that correct?
Mr. Chair, yes, I believe so under this definition, given that, if the purpose is for investment. Yes.
And is there, if I'm reading this correctly, it applies to interests in property acquired on or after the effective date. So it sounds like any existing companies, private equity companies that already own over 100 properties would not be forced to sell anything. They would simply be prohibited from acquiring any more. Is that correct?
Thank you, Mr. Chair. Yes, that is correct. It is purely forward-looking. It would not, yes, you are correct.
Okay, and then you've identified among the concerns the density of private equity-owned homes in certain areas. Does the bill address anything with regard to density, or is it simply a cap on the numbers regardless of how many are owned anywhere in the state? Senator Boldon.
Thank you, Mr. Chair. It is the latter. It is that 100 cap includes all over the state, so there's not specificity in the language about density.
So if someone owned 100 homes and they own 25 in Minneapolis, 25 in St. Paul, 25 in St. Cloud, and 25 in Duluth, they would still be prohibited even if their homes are scattered in terms of concentration. Is that correct, Senator Boldon?
Yes, thank you, Mr. Chair. Yes, that is correct. If a private equity company, as defined in this language, owns 100 homes anywhere in the state, this would apply to them. As I would just add that, we have housing crisis all over the state, and really this is intended to level that playing field. And often we are seeing these private equity companies come in and, they're able to put up a cash offer, oftentimes, at or above asking. They can waive an inspection, and it doesn't allow people living in those communities to have even a chance to be able to purchase those homes. And so we want to try to level that playing field. So yes, this would, regardless of where those houses are across the state, it's that 100 home cap would apply.
Okay. And how was the figure 100 arrived at? Can you help me?
Yes.
Senator Boldon.
Thank you, Mr. Chair. That is an excellent question. We have had much discussion about that. Again, it is, sort of compromise and working with my Republican colleagues in the Housing Committee. We landed there. Certainly, our intention is not to affect sort of like mom and pop entities. We recognize that is, something that happens across the state, and we're not looking to impact that. So we wanted it to be high enough that we're not sort of, harming the little guy, so to speak, but also want it to have an impact. And so we also, the Minneapolis Fed has a tool and data, so we can sort of look to see where is this happening, how much is this happening, is there sort of a natural break of entities and how many homes they own. own. We also looked at other states who have enacted similar legislation and where did they land. And so it is a combination of the two. It is there are other states who have landed at about that place. And at 100 homes, this captures or would capture the largest entities in the state who are doing this, and would not capture many of the smaller ones. So it's a negotiation and a compromise.
And Senator Boldon, do you know how many entities then would be covered by this? How many are above 100 now, so they'd immediately be affected?
Thank you, Mr. Chair. I think it's roughly 5. And sorry, again, Mr. Chair, just to point that it is forward-looking, and so it would not require those entities to divest of any of their properties. It purely is forward-looking.
And then you said you had conversations with your GOP colleagues on this. Did you have conversations with stakeholders and stakeholder input as well? And if so, which stakeholders?
Thank you, Mr. Chair. Yes, have had many conversations about this topic over time, both in terms of individuals who have been impacted by this. As I mentioned, Homeline, Legal Aid, the realtors have been in contact with, as the Minneapolis Fed, a number of entities that have stakeholders in this space.
I know I've received some input that there's some concern about this making it more difficult for families to find rental homes rather than finding rental apartments. I know it's hard enough to find rental apartments in the affordable space, but there are people who would like to own a home or would like to live in a home that don't have the ability to purchase one, but would have the ability to rent one. Have you gotten any input or had conversations on that topic? Senator Boldon.
Thank you, Mr. Chair. I appreciate that question. I think to that point, I would say, again, trying to level the playing field a little bit. Certainly, this would expand opportunity for individuals in community to purchase homes. Recognize that not everybody is able to do that or wants to do that. This also would allow those smaller entities to purchase homes and rent them out. Those mom and pop folks that own, maybe just a handful of homes, or up to 100 homes. If there's 100 homes is a lot. So this, I don't necessarily think this is going to have a dramatic impact in lessening rental opportunities. I think that still will happen through the natural course. What I do think it will limit, which is a good thing, is some of the sort of predatory behaviors or just like neglectful behaviors that we are seeing from these private equity companies. I would, again, encourage you to read the letters in your packets from a couple of individuals who have had experience with those. And it's, they can't get a hold of people. One person describes, the basement flooded and it was, like over many days before they, were able to like come and address it. And those aren't just one-off circumstances. This is what I hear from many, many folks for this experience, that the landlords are, not able to reach them. The emergency line doesn't work. They aren't able to get things repaired and upkeep, maintenance kinds of things. And so we want people to have those rental opportunities, and I think that will still occur, but it will limit some of those really harmful behaviors that we are seeing from private equity companies.
Thank you, Senator Boldon. Any questions or discussion from members of the committee? Senator Limmer and then Senator Holmstrom.
Thank you, Mr. Chair. Senator Boldon, you make reference to a U.S. code on lines 2.8. And could you tell me what the definition of the real estate investment trust is in light of the U.S. code site that you have in your bill?
Senator Boldon.
Thank you, Madam Chair. Thank you for the question, Senator Limmer. I do not have that definition in front of me. I might ask counsel to back me up there.
Senator Limmer, where are you on which line? Because we were on the A9 amendment for discussion purposes.
I'm sorry.
Just so we track, are you off the A9?
Yeah, on the original bill, lines 2.8 of the original bill.
Council, do you have an answer to Senator Limmer's question? Ms. Primo.
Mr. Chair, members, I have the definition. I could read it if that's the preference. A real estate investment trust means a corporation, trust, or association which is managed by one or more trustees or directors, the beneficial ownership of which is evidenced by transferable shares or by transferable certificates of beneficial interest, which, but for the provisions of this definition would be taxable as a domestic corporation, which is neither a financial institution referred to in another section of the act of the statute or the code, nor B, an insurance company to which another provision applies, the beneficial ownership of which is held by 100 or more persons, subject to the provisions of some additional sections within this code, which is not closely held as determined under those sections, and which meets some additional requirements in another subsection. So that's the definition, but clearly there's a lot of different limitations that apply that are described within this code, and I can send a link to this to Senator Limmer if there's a preference for that.
Mr. Chair, the only reason I brought that up is I was concerned about the smaller investor. A lot of our individuals that are facing retirement, they might find a neighborhood home that they're renting out for a little extra retirement money. And but after hearing the definition on the U.S. code, it does define it as a membership factor of 100 or more people that would be involved. Is that correct, Council? So
Primo.
that would not affect an LLC, let's say, of an individual or a couple that are investing in a real estate venture.
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Limmer, for the question. So what you're describing of, an individual or a couple or an individual and even a couple of other people, purchasing a home in their neighborhood after retirement, this bill would not affect them. It would not affect that kind of behavior. And I'll also just note what you're asking about on line 2.8, that real estate investment trust is also excluded from the bill, and so would not be included.
So, Mr. Chair, just a question. An individual or a couple that own an LLC, they would not be affected by this provision. Is that correct?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Limmer. They would not unless they purchase up to 100 homes.
Or over 100.
Over 100 homes, yes.
Yeah, I don't think in that case that would happen too often.
Although, Mr. Chair, I will thank you, Mr. Chair. I will note if it is a married couple, there are exceptions for family entities in this bill as well. So if they're a married couple, they could have over 100 homes.
Senator Boldon, just to be clear, on the A9 line 1.4, it says interest in fewer than 100 single-family homes are exempted. So 100 or more would not be exempted. Is that correct? Senator Boldon.
Yes, thank you, Mr. Chair. Thank you for that clarification. Yes, you are correct.
Senator Holmstrom, I'm happy to broaden the discussion after we adopt the A9. Is your comment or question to the A9 amendment specifically? Yes and no?
It's in the definition of private equity company. It could probably be addressed afterwards.
Well, private equity company is referenced throughout the A9, so why don't you go ahead, Senator Holmstrom.
Thank you, Mr. Chair. Senator Boldon, right now in Congress, there's HF 6644. It's a bipartisan bill to do exactly what this is doing. And instead of private equity company as the mechanism to define these entities, they use a different definition, but it seems to accomplish the same goal. Did you consider that definition? And I ask because this has passed the House and the Senate, and it's probably going to hit the president's desk, so there might be an interest in, if we want to their limit is 350 single-family homes. I understand saying maybe we want less than that in Minnesota, but it would make sense if we didn't have two different standards for the law, if we just followed one definition. So how much did you look at that?
Senator Boldon.
Thank you, Mr. Chair. Thank you for the question. We did look at that, and I will say I'm not entirely opposed to that idea. As I mentioned, we have been working on this language for, this is my fourth session working on this language, and so had started this work before that bill came about, before that work was happening, and so sort of stuck with kind of what we had been working with over time, but did look at that and know that work is happening, and as I said, I'm not entirely opposed to that.
Senator Holmstrom.
Okay, and what's the path for this bill today?
This would go, there's a fiscal note, so it would go from here to finance as expected. It's already been through housing.
Okay.
Senator Holmstrom.
So with that, if we're still not solid on that language, or rather on that definition, or what we want to do with it, in my head, I'd want to kick it back to housing, but it's your bill, so I'll leave it there.
Is there any further discussion on the A9 amendment?
Mr. Chair.
Senator Westrom.
Mr. Chair, could you just ask staff to release it? I don't seem to have it on my system, the A9, but I think I'm following it pretty close. But if they could, and I have a question in the meantime.
Yes, staff will make sure that you get a copy of the A9 amendment, Senator. Go ahead with your question.
Mr. Chair, Senator Boldon, in your opening remarks on the bill, you said you were using ownership of 42% of the houses around the University of Minnesota were owned by investors. So my question is, how is this bill going to change that, and how is it relevant to that? I know one of our local dentists owns one of those houses as an investment property. His daughter went to college there. They bought it when she was in college, and he uses it as a rental property, investment property still today. Is your effort in using that analogy to get rid of all of those houses? And then my question is, who's going to own them if it can't be an investor? Because generally that's who's going to own a rental property near a college or elsewhere. And so I'm just trying to square your introduction with the gist of the bill and what we might be missing.
Senator Boldon.
Thank you, Mr. Chair. Thank you for the question. I will say, unless that dentist owns 99 or 98 other properties and wants to buy another, this bill will not impact them. My intention of sort of citing those statistics is to illustrate the how widespread this issue is. The issue of these private equity companies purchasing single-family homes is a significant issue, and it is growing. And so this bill will not decrease that. Again, this is only forward-looking, and so it is not going to require any of those folks who or entities who own those homes to divest of those properties, but it will try to get at the problem as we move forward, a problem that is increasing and a problem that is pushing regular Minnesotans out of the homeownership market, that they just are not able to compete with these very large companies with very deep pockets to purchase homes in neighborhoods.
So two more questions. We'll try to wrap them into one, Mr. Chair. Senator Bolton, you referenced the LLC in Senator Limmer's question, but if the husband and wife were married, they would be exempt. Is that exempt from the 100 number cap completely because they are a small LLC and just family-owned, husband-wife? It'd be similar, maybe son and daughter are in the same LLC, but it's a closely held entity, basically, with the family. Are they totally exempt? And then I guess that's the question. Maybe I'll let you answer that first, and then I do have a brief follow-up.
Senator Boldon.
Thank you, Mr. Chair. Senator Westrom, they would be exempt because of line 2.7, which exempts a family entity. And then I would point you to line 1.10, which defines a family entity, is then the lines after that define it, where people are natural persons related to each other within third degree of kindred. And so because they meet that definition of family entity, because they are related, they would be exempt even from the 100 home cap. Yes.
Thanks. So, Senator Westrom. By the way, the amendment has been posted, Senator Westrom, so you should be able to have it on your system.
Okay, very good. Thank you. Senator Boldon, so we see lots of ads on TV, some of them quite clever, a mom and a dad and a daughter, or one of the ads, I forget the name of their company, but it's everything from Homestead Road to WeBuyUglyHouses.com to other companies. Are these kind of the target? You're saying we don't want you to continue doing this. Would they be part of the group that going forward wouldn't be able to participate in this market if there are over 100 homes? Is that kind of the gist of it?
Senator Boldon.
Thank you, Mr. Chair. Senator Westrom, I'm not familiar with those commercials, so I'm not sure that I can speak exactly to those, but I think I heard you reference a father and a daughter. They would not be impacted by this, as they are related and would be a family entity as defined by this, so they could own as many homes as they like. But it is attempting to get at the, as we have defined, the private equity companies, these very large groups with close to unlimited spending power that are just can come in and buy up single family homes. Sometimes they buy, a number of houses on a block. And so we really are not aiming to get at, small LLCs, families that are, purchasing homes as a way of, additional income, or, it's a way to, improve generational wealth. We are not trying to get at those smaller entities. We really are trying to get at the big corporations, which is, again, why we've, sort of landed at that 100 home cap, which really only captures a pretty small number of entities in the state.
Senator Boldon, it also appears that exempted from this definition of private equity company would be a corporation primarily engaged in housing development through the construction or substantial rehabilitation of single-family homes. So if any of those companies buy up homes, buying ugly houses or whatever, with the intention of rehabilitating them, renovating them, and then selling them back into the market, that would not be covered here. Is that correct?
Thank you, Madam Chair. Mr. Chair, that is absolutely correct.
Thank you. Senator Westrom, anything further?
No, not right now, Mr. Chair.
All right. Senator Holmstrom, on the A9.
You addressed it with your comments.
This might make you nervous, Senator Holmstrom, if we are on the same page here. That's
oh, no. Oh, no.
What have we done?
Mr. Chair.
Senator Westland.
I'm just going to actually make a suggestion that in line 1.13 we change the word kindred to consanguinity. But I will not make a formal motion for that.
Thank you for not doing that. On the A9 amendment, any further discussion? Seeing none, all in favor of the A9? Wait, we need a motion. Senator Clark moves adoption of the A9 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Members, will continue the discussion, but I just want to let you know logistically, I am getting lunch for everyone on the committee and staff. Pizza should be arriving shortly, so as soon as we are done with this bill, we will take a break for lunch. A couple of us also have to go over to the Commerce Committee for some votes, so the plan is to recess for lunch and reconvene as soon as we can return from Commerce Committee and eat some cold pizza at that point. So, Senator Cruin to the bill as amended, and then Senator Limmer.
Thank you, Mr. Chair. My question is on the definition of private equity company. I don't think my question is affected by the adoption or not adoption of the A9, so I was waiting for that amendment to be adopted. But my understanding of a private equity company, notwithstanding this definition, would be a company that raises capital out, and you can buy and sell shares of that company. But is the intention of your bill, before we get into the definition, is the intention of your bill, let's say you have a company in Minnesota whose business model is to buy single-family homes. They're not buying and selling shares of their company, but that is their business model, and they raise funds through loans or whatever, and their business model is they have a company, and then each one of their single-family homes is a separate LLC, which is pretty common when you're doing that. Each property you buy is going to be an LLC, and then you kind of have a parent company above it. Is the intention of your bill to restrict those companies to fewer than 100?
Senator Boldon.
Thank you, Mr. Chair. As I think I'm following your question, Senator Kroon, and I would say yes. I would point folks to line 1.5 on the A9 amendment. Part of our conversation was with the 100-home cap. And again, we're trying to get at these very large companies who are, this is their business, this is what they are doing. Part of our conversation with that 100-home cap was, well, could corporations sort of do what I think you're saying is kind of make shell companies underneath them to sort of get around the 100 homes, have 50 over here, 50 over here. We don't want entities to be able to sort of skirt around this law to do that. So we do have language trying to get at that at 1.5 and 1.6 on the A9 amendment.
Senator Kroon.
Thank you, Mr. Chair. Not exactly my question. Maybe I inartfully asked it, because my question is getting kind of at how the business does or does not raise funds to operate. So let's assume a scenario where we'll set aside the fact that each single-family residence has its own LLC. Let's just assume it's all one company. It doesn't really matter for purposes of my question. Let's say they're not out selling shares of their company. They're not out raising private capital. They're getting bank loans or however to acquire these properties, but they become really large, and then they use the profits from their business operations to buy more single-family houses. They're not buying and selling shares of their company, but they get to a point where they have over 100 single-family houses. Would your bill apply to that company?
Senator Boldon.
Thank you, Mr. Chair. As I understand your question, I think the answer would be yes. That is what we are trying to get at. I think regardless of how companies raise their capital, that could happen in a number of different ways. But if they are meeting this definition of a private equity company, if they are a group of investors who are purchasing single-family homes as defined here, they would be limited to under 100 homes. Yes.
Chair.
Senator Kroon.
Thank you, Mr. Chair. But what if they're not a group of investors? Because I focused in on the term investment firm on line 1.20. I don't know exactly what that means. I was going to ask you that, but I guess in my thing, let's say it's one individual person who forms a company, and he gets financing from a bank to buy the first one and maybe the first few, but then the business operations kick in. He just keeps growing and growing and growing, and eventually ends up over 100. There's no group of investors. He's not an investor. He's just in it as a business to make money, and he's grown to the point where he has over 100. Would your bill cap him at 99, and he'd have to stop growing at that point?
Senator Boldon.
Thank you, Mr. Chair. I'm assuming that it's this individual who is doing this has a company, that they're not just doing it in their individual name. So that company, I think, as I understand you're asking, I think yes, would be limited, would sort of meet that definition, and would be limited to 99 homes.
Thank you, Mr. Chair.
Senator Kroon.
And thank you for that answer. I mean, that saves a lot of questions I was going to ask, because I thought the intent of your bill was to kind of get at the traditional private equity companies that go out and seek money, capital from investors, and then come in and buy large swaths of single-family homes disrupting the market. That's something I think a lot of people are concerned about, including me. I don't know how much of an impact it has yet, but theoretically it could have quite an impact on the markets, and it could lead to artificially making single-family homes more expensive, particularly for first-time home buyers, which is a huge problem right now. But I'm a little more uncomfortable with the idea of just a business, not private equity, not out raising capital, but just through regular business operations, limiting the growth of that company. I think there's a distinction there. And I'm a little uncomfortable limiting that company who's just growing through its own business operations, who's not out raising capital and doing it that way. I think there's probably a distinction there. It sounds like the intent of this bill is to capture both of those. But I'll have to chew on that a little bit more, because I was going to really start parsing out the definition, but given the fact that you think the intent of your bill is to cover both of those scenarios, I won't have to do that. Thanks.
Senator Limmer.
Thank you, Mr. Chair. Senator Boldon, as I've been listening to the bill presentation, I'm always kind of thinking, what would be a situation that may cause an unintended consequence? And I came up with one. On occasion, there are developers or builders that build a development intended for sale of a great number of homes in a development, or townhome development where they're closely quartered, or even a condominium building that's going up in the sky. A lot of building units are being built at the same time, and suddenly, due to no fault of their own, they have to file bankruptcy, and the whole development has to be sold. And there will be investors that are going to be interested in those, but if the number of units are over 100 units, does your bill prohibit a sale of the entire development of 100 plus homes at the same time?
Senator Boldon.
Thank you, Mr. Chair. I guess I would direct members to lines 2.2 and 2.3, and sort of back to comments that Chair Latz made. If the intention is building, rehabilitating. The intention of this bill is not to, limit. We need more homes. We don't want to limit supply and limit building. And so, if the intention is, building those homes, it would not apply.
Well, I'm looking at 2.2 and 2.3. That would be provided that it's a nonprofit organization. But I'm thinking of the for-profit All-American Corporation that wants to make money. And they find a development that's facing bankruptcy, they want to buy it and then resell it. But they might need to season that property because there's a reason why it's going under bankruptcy, and so they're going to hold it for a while, season it on the rental market, and then sell it out individually later. Or maybe they sell it out separately, but they're all individually licensed or titled, and so this does happen. It doesn't happen a lot, thank goodness, but it does happen. I'm just concerned that it might just be an investment company that's looking for an opportunity. They may not be involved in construction, but they are interested in buying something low and selling high. And I'm hoping that it's not an unintended consequence, that would prevent that corporation from buying something that has over 100 units.
Is there a follow-up question there, Senator Limmer, or statement at that point?
Well, it's my concern. I'm trying to get some type of satisfaction that we're not prohibiting a corporation from investing in something like that, which would be a bigger sale. It's not the individual residential sale that you're talking about. It's talking about a whole development that may be facing bankruptcy, and a second party wants to come along, a corporation, an investment firm. Maybe it's sitting out in Washington or in New York City, but they search for these properties, and I just think that maybe we may be prohibiting a corporation from buying out a whole development.
Any follow-up, Senator Boldon?
Thank you, Mr. Chair. I don't know if this will help you, Senator Lerm, or not, but I also would direct you to just the lines below, the ones I mentioned, 2.4, 2.5. If it's not a nonprofit, it talks about a corporation primarily engaged in housing development and construction. So again, not aiming to limit construction, but I think maybe what you're describing, again, the intent of this bill, and I want to circle back to maybe Senator Kroon's question earlier, because I'm not sure I understood correctly, maybe necessarily got at that. But to Senator Limmer, what you're saying, this is aiming to limit the behavior of very large investment corporations from purchasing, a swath of single-family homes. So because of the reasons we talked about of, trying to level that playing field, allow Minnesotans to be able to purchase those homes. And so if it's development, that's sort of excluded here. That's not what we're getting at. But do want to give Minnesotans a chance in the market. And maybe I'll just take this opportunity, Senator Kroon, back to your question in looking at the definition of private equity companies. I might, Mr. Chair, if you allow it, ask counsel to maybe speak to that definition if what Senator Kroon was describing with an individual would be included in that private equity company definition.
Ms. Primo.
Mr. Chair and members, so the main definition is that beginning sentence at line 1.17 to 1.19, and thinking back to the way Senator Kroon described that corporate entity, it did not sound like that entity would be engaged in the raising and returning of capital. And I don't know if this definition would apply to that sort of entity, because the goal, as I read it, is to apply to private equity funds, private equity entities who engage in that sort of raising of capital. And maybe there's some room to clarify, depending on what the intent is, whether to apply it to those entities that Senator Kroon described or to not. There may be a possibility to refine that further.
Senator Limmer.
Thank you, Mr. Chair. I hope I'm not being sidelined by the question I asked and then shifting to Senator Kroon. But the way I see lines 2.4 in reference to a corporation, there are other corporations that make investments. They are not primarily engaged in housing developments or rehabilitation construction. That's the focus I'm looking at. These are large investment firms, usually out east, Chicago. They have affiliated offices in Minnesota, but they look for any opportunity to make investments. And sometimes they run into a development that may be over 100 units, and they want to buy it. And then eventually they want to make profit on it. And the way I'm reading it, I just see a gap in a corporation that wants to buy those things. There's fewer and fewer of them because it's a very costly investment, but I don't see it covered here. And I think your bill would prohibit them from working in Minnesota if they're, let's say, trying to bail out a company that is in bankruptcy or default. And that's the only reason I bring it up. I just think there's something missing here. And inadvertently, unintended consequence means that they will be prohibited from doing business in the state of Minnesota. And then what happens to that property that's facing bankruptcy is it just going to sit there? You know, I don't know, but that could eventually cause blight in the community. And in some cities, there are developments that happen like that, and due to some oversight in the law, they become vacant, and then it just sits there for a while. And we don't want that to happen either.
Any further discussion on Senate File 3173 as amended? Senator Clark.
Thank you, Chair, and thank you, Senator Boldon. I think what I appreciate about this is we're really getting at what I think Senator Limmer was describing, which was that there are swaths of homes that end up being abandoned or ignored and underinvested in. I think that's part of what we saw in stories throughout the metro with private equity firms that went sideways, and we could not figure out who was in charge to address them, to address the issues that were being caused by absentee landlords who, if they were more local, we would, or been more mom and pop, wouldn't have had such the worry. So this is sort of putting a corrective on the market to make it a more fair market, a market that works for all of us. And it avoids what Senator Limmer described, which was vacant homes that were being ignored. And I think we may have a bit more work that we need to do as we go forward, but this is a good step where you've worked with our partners throughout the housing community and the housing committee, both Republicans and Democrats, to craft something that works as a good step forward. So it's part of why I'm proud to have my name on the bill, and let's keep moving this forward, because it avoids a lot of what I think we've been describing here, and it keeps families and small operators in to take care of their investments that they've really spent a lot of time being proud of. Thank you.
Any further discussion? Not seeing any. Senator Clark moves that Senate File 3173 as amended be recommended to pass and be re-referred to the Finance Committee. All those in favor say aye. Aye. Opposed?
No.
Motion prevails. Members, we are in recess. Pizza's on the table across the room from the pages. Research folks behind the wall. So help yourself. I think Senator Westland and I are going to be, well, she's already gone. Well, I'm heading to Commerce. We'll be back and we'll reconvene whenever and as soon as we can. Thank you. We are in recess.